Namaste everyone, my name is Pranav and I am from Faculty of Non-Governance, and in this video I am going to talk about legal positivism. What is legal positivism? So the term legal positivism is used here to signify a doctrine which rejects any metaphysical speculation concerning the law and which studies a community's laws precisely as they are, without taking into account matters such as social context, political and psychological background, and all these things are considered extraneous. So when we study legal positivism, so the basic features of this doctrine, its methodology and claims are not or will be discussed later in this session. So it is important initially to distinguish the term legal positivism from philosophical and logical positivism. Although it should be noted that legal positivism has been influenced by writings of the philosophical and logical positivists. Philosophical positivism is a doctrine which holds that our knowledge is which holds that our knowledge of matters of fact is derived solely from the data of experience. Metaphysical, so-called transcendental knowledge, which is not based on experience, is held to be extraneous, of no value in legal positivism. Logical positivism, which stems from the writing of Carnap, Wittgenstein, Hare, and others of Vienna Circle, involves a total rejection of statements that are not based on tested and verified experiences of the senses. Meaning is ultimately to be established solely in terms of experience, so that metaphysical assertions are dismissed as meaningless. So any kind of internal experience, such as reason or divine interpretation, are termed meaningless. So positivism is nothing but basically fact and values distinction. Positivism is all about fact, and anything which considers value renders it meaningless in the eyes of a positivist. Hart, who urges the significance of understanding the mode in which statements about the laws are couched. Fundamental to legal positivism is its attitude to the problem of is and ought. Positivists ask us to consider the use of ought in sentences such as, if I release the pen that I am holding, if I release the pen that I am holding, it ought to fall on the ground. You ought not to steal. Those who kill ought to be punished severely. Here the term ought may refer to what is likely to happen as a physical probability, or it may be used as a moral ought. May one without fallacy deduce ought from is. May we infer a normative statement from a merely factual statement. The answer of the legal positivist is that if normative rules reflect no more than subjective opinions, they cannot be deduced from physical reality. What then is the value said to be derived from search for the moral verities presumed to be at the basis of law? What is the point in basing legislation on so-called immutable principles, so-called moral principles, which in themselves possess no veracity? Analysis involves concentrating on a study of the law as it is. That is, that the law posited, the law positioned, that is laid down for citizens. Now, Bentham has argued in his A Fragment on Government that it is possible to consider jurisprudence as comprising two modes of analysis: the expository and the censorial. Expository jurisprudence involved identifying the essence of law as it is. This demands purely scientific consideration of the true propositions of English law, which will lead in turn to a study of source of legal commands which are at the heart of the law. Whereas censorial necessitates a consideration of what our law ought to be. These are two types of jurisprudence are to be accepted as logically separate and not never to be thought as a unified jurisprudential outlook. Today's legal positivists keep in mind the fundamental separation made by Bentham. It emerges when they urge that what is to be accepted as law in given community is derived from social fact or convention, the so-called social concept, and that it is not possible to perceive any obvious or necessary links between law and morality, the so-called separability concept. Now, if we look at the past, David Hume, the 18th century Scottish philosopher, developed the doctrine of empiricism, which called for a detailed observation of phenomena as the basis of scientific investigation. He used this method of inquiry in an examination of natural law. To Hume, the natural law was real only in the sense that some person entertained feelings that is existed. There was no other sense in which its truth might be asserted meaningful. The truths which some jurists saw in natural law based upon reasonable human conduct could not be demonstrated. So-called guides to human action were merely relative values inspired directly by human motives. They required no eternal framework. Now, Hume's thought were enlarged by Augustine in the following century. Now, he taught that a priori, as we have discussed in previous sessions, a priori, a metaphysical speculation, actually has no validity, and that all theories should be subjected to rigorous empirical investigation. Comte's writings were among the first to contain the term positivism used in a philosophical sense. The teachings of Hume and Comte cleared the way for the implication of precise modes of reasoning to problems of jurisprudence. The law, until now, the object of metaphysical speculation, was now subjected to analysis of the basis of experience. In particular, a growing number of jurists followed Bentham and insisted on the separation of what and is. It was felt that some of the methods of natural sciences might be considered appropriate to the study of social sciences, including legal theory. Now, in Hart's The Concept of Law, 5 uses of term positivism in relation to Anglo-American jurisprudence are noted. First, the term is used to describe the concept of law, favored by Bentham and Austin, in which laws are seen as the commands of human being, in which laws seen as social concept. Secondly, the term is used to describe the views that there is no necessary link between law and morals, separability concept. And as emphasized by Kelsen, that law needs no backing. Law in itself is independent. Law is pure. Now, third, the term is employed to name the idea of analysis or a study of meanings of legal concepts. Now, fourthly, the term denotes the view that a legal system is closed logical system in which the logical means alone are to be used to decide and to deduce correct decisions from predetermined legal norms or rules. Finally, the term is used to indicate the theory that moral judgments cannot be established as can statement of fact by rational argument, by providing evidence, by providing proof. Hart himself uses the term legal positivism. So in his chapter on natural law and legal positivism, to show that it is not a necessary truth that law reproduce or satisfy certain demands of morality, though they may often have done so. Raz suggests in the same length that a jurisprudential theory is acceptable only if it tests for identifying the content of law and determining its existence dependent totally on those facts of human behavior, capable of description in terms which are value neutral and which are applied without using moral argument. The social sources of the law will determine its very content. So, among many legal positivists, there is shared approach to methodology of investigation of legal problems. This approach involves an investigation of the structure of laws within a legal system so as to reveal their real foundation. A classification of the function of the legal system is undertaken. Concepts within the legal structure require identification and analysis. The legal positivist uses these techniques to answer questions such as what is law, what are laws, what are the essential functions of laws. Now, positivists seek to exclude value judgments and moral considerations from their examination, investigation, analysis of the law. To quote Austin, the existence of law is one thing, but its merit or demerit is another. Here you will see he specifically excluded the value part from the law, that is the merit or demerit. This is not to imply that positivists are not interested in matters of morality in relation to the law, for this is demonstrably not so. Many leading positivists have contributed in great measure to debate and social movements associated with problems of social morality. Now, it is in the examination of legal phenomena such as that positivists will set aside moral considerations, as will an epidemiologist investigation the incidence of a disease within the community. Right? The positivist data in relation to legal matters is intended to emerge from a study of social reality only. Now, criticisms of legal positivism are headed by general attack on the theoretical foundations of Humean doctrine. The basic theory, it is said, is flawed, and its rejection of metaphysical speculation has resulted in attempts to remove the attention of jurists large area of significant intellectual human activity. They reduce the importance of intellectualism. The positivists are, however, not convinced that the flaws of Humean analysis have been demonstrated satisfactorily. Hume has constructed a system of investigation which can explain the phenomenon of the world, including law and the workings of legal institutions. Further condemnation of legal positivism is stemming from the dissatisfaction of its basic portion or basic position is centered on its preoccupation with a search for facts without giving an attention to the possibility of an underlying unifying purpose in law. So the positivists' exclusion from an investigation of legal facts of the entire context of the law is criticized by those who maintain that law only exists within a social setting and that it cannot be investigated adequately if that setting is ignored. We will see in coming lectures how Austin, how Hart, and how Kelson has gone on with this idea of legal positivism. Till then, thank you.